Hello everyone. I'm pleased to be with you today to discuss the European Whistleblower Directive, what it is, what its implications are for whistleblowers in the EU, and how it affects employers' compliance obligations. My name is Johanna Schwartz-Mirales. I am of counsel at Delcade, a boutique French business law firm with offices in Paris, Bordeaux, Lille, and Biarritz. Today we are going to discuss the European Directive on the protection of persons who report breaches of union law, which, for ease of reference, I'll refer to as the European Whistleblower Directive. This law was adopted by the European Parliament and Council on October 23, 2019, and it came into force on November 27th of that year. On paper, the directive required EU member states to adopt what we'll call implementing legislation on or before December 17th, 2021. This is also known as transposing the directive. As we'll see later on in the presentation, various countries are more or less on schedule in this transposition process. But all of them ultimately will be responsible for compliance with the directive. And the legislative changes that will result will have broad-reaching effects in terms of whistleblower protection and compliance in Europe. So today's discussion will proceed in three main parts. First, we'll review the directive and its key provisions. Second, we'll look at the current state of transposition. And third and finally, we'll discuss what recent legislative changes mean for employers with operations in Europe. Before diving into the directive, however, I think it's helpful to give some general background on whistleblower laws in Europe. Looking back, Europe has been about 30 years behind the US in terms of legal and cultural developments in the fields of whistleblower protection and compliance more broadly. Whereas American courts and legislators started taking an interest in whistleblower protection in the early 1970s, it wasn't until 1998 that the first standalone whistleblower protection statute was adopted in a European country. This was the Public Interest Disclosure Act in the UK, which has since undergone some amendment but remains in force today. From there was not much legislative action, except as it concerns general workplace anti-harassment and anti-discrimination legislation until the 2010s. But in the last 10 years or so, European countries have finally started to legislate. The recent increase in interest in whistleblower protections can be attributed to a number of factors. These include globalization, advocacy on the part of whistleblower protection NGOs, and media coverage of sensational whistleblowing events like Edward Snowden's disclosures of NSA surveillance, the Chelsea Manning affair, the Panama Papers, and LuxLeaks, which, for those of you who aren't familiar with that event, was a scandal in Europe involving the disclosure by a PwC auditor of tax rulings affording favorable tax treatment by the Luxembourgish government to some multinational corporations. This nascent interest in whistleblower protection legislation was evident both at the level of individual countries in Europe and at the European level, where certain regulations and directives adopted prior to the new whistleblower directive already contained sector-specific whistleblower protections. And one example of this at the European level is the market abuse regulation. So these are laws that afforded whistleblower protection, but only in certain specific contexts. So for the disclosures of certain types of information or as applied to certain kinds of employers. It's also important to note that even before European countries adopted specific whistleblower protection laws, European whistleblowers were not entirely at the mercy of those who might seek to retaliate.